Welcome to part 2 of our week 4 discussion about torts. We've already looked at intentional torts in part 1. In part 2, we're going to look at negligence, which is an unintentional tort, as well as strict liability, which comes up in the context of products liability. Well, we already looked at intentional torts. In other words, torts that are committed on purpose. The person committing the tort intended to do something naughty. What we're going to look at now is different than that. These are not committed on purpose. Sometimes people just do stupid things that cause damage to people around them. They're careless or not paying attention. They take risks that they ought not to take, but they never intended for anyone to get hurt or anything bad to happen. But because they were an idiot, something goes wrong. And that's what we're going to be looking at specifically with negligence. It's an unintentional tort. They never intended for harm to occur, but harm did occur because they were at fault. And so we're going to be looking at how that works. Again, we refer to these incidents as unintentional torts. There was no intent requirement here. We don't have to look into the person's heart and see that they had, some kind of evil motivation. Just being careless is enough here. And really, there's only one type of unintentional tort that we deal with, and that's negligence. Negligence is hugely important. It comes up in lots of different situations, so we're going to spend a lot of time looking at it. Most cases, for instance, probably that clog up our court system a lot, car accidents, medical malpractice, things like that, deal entirely with a claim of negligence. But it crops up in business litigation all the time, too. So it's hugely important. We need to have a really good understanding of what negligence is if we're going to be well-rounded business people. Like all other torts, negligence is composed of several elements. All of these elements have to be satisfied before we have liability. And I will harp on that because I've had a lot of students that would focus in on one of these and say, oh no, there was a breach of duty, we need to sue someone. Well, only if we have all the other elements too. So let's look at these elements. First of all, and we'll look at all these in more detail later, so don't panic. I will explain all these in some detail. Anyway, first element, the defendant must owe a duty of care to the plaintiff, and we'll look at what that means here just shortly. Second, the defendant must breach this duty of care. So they owe a duty and they screw up. They breach that duty. Because of this, the plaintiff suffers some kind of injury or damages. And the damages were caused by the breach of duty. And this is what we call cause in fact. But for this breach, these damages would not have occurred. And we have to have also the fifth one. The damages to the plaintiff were foreseeable, and that's called proximate cause. And we'll, again, look at all of these in some detail. But while we're all here on the screen, let me stress at you one more time. You cannot sue someone based upon one of these elements. You have to have all five before you have a claim of negligence. If somebody does something bad, you do not go to court and sue this person for breach of duty. Breach of duty is 1/5 of a tort. It's not a tort. You have to have all the rest of them too. So don't forget that. You have to have all of these elements working together before we have negligence. The first element of negligence is the duty of care. What does this mean? Well, in order for there to be negligence, the defendant first had to owe a duty of care. Well, what kind of duty are we talking about? Well, we're all obligated to act as a reasonably careful person would in order to avoid harming those around us. If we're driving a car, a reasonably careful person would keep their eyes on the road, would not be checking their Facebook, would not be drunk. There's a number of different things that we could look at, but we need to act as a reasonably careful person would in order to avoid harming people around us. And that is what we call a standard of care. The duty that we owe to other people, that's our standard of care. And if we fall below that standard of care, then we have a problem. We might be working on committing negligence here. In most situations, going through our daily lives, we have the duty to act as a reasonably careful person would in the same or similar circumstances. This is what we call the duty of ordinary care. And this is what our standard of care is in most everyday situations, when we're driving our car, when we're walking around campus or whatever. we ought not be doing things that a reasonably careful person wouldn't do because they might harm somebody else. And so that's just ordinary care. We have to be a good citizen, kind of the golden rule kind of thing, do unto others or whatever. We need to be acting, reasonably, carefully, not doing overtly dangerous things that would put other people in harm's way. So that's our duty of ordinary care. Sometimes the standard of care is higher in a particular situation. For instance, a doctor treating a patient is held to the standard of care that a reasonably careful doctor in that specialty would have. And so that's a higher burden. If you're a cardiologist treating a patient, you're held to the standard of what a reasonably careful cardiologist would be doing. So with all that education and experience and training and what have you. So certain situations, our duty of care is much higher. A lawyer has to be very careful in handling a client's affairs, or an accountant, and a client or whatever. But ordinarily we have the duty of ordinary care at least. We may have something more than that. It just kind of depends a little bit on the situation. And going the other direction, a child is not going to be held to the same standard of care that an adult would, because they're kids. They're not capable of being that careful. And so we would look at what a reasonable child of the same age and experience would have. So, if is your 6-year-old acting more dangerously than a regular 6-year-old would, that's what we're looking at. So when we're defining negligence. And so it kind of does depend on the actor a little bit, but there is, for most adults, there's that reasonable, careful person standard. It's kind of an objective standard. You may be an idiot, but we expect you to be act like a normal, careful person would. So let's look at an example now. Example 19, Rosie went to see Dr. Smith, who is a general practitioner. Dr. Smith took an x-ray and thought there might be a cancerous tumor. He didn't tell Rosie this, but did refer her to a specialist, Dr. Jones. Dr. Smith sent the x-rays to Dr. Jones for her to review. However, Rosie canceled and rescheduled her appointment with Dr. Jones 3 times. Finally, she canceled entirely, never did see Dr. Jones. Rosie then died of cancer. So her husband comes along and sues Dr. Smith and Dr. Jones for medical malpractice, which is a type of negligence. Dr. Jones argued she never even saw Rosie, so she never had a doctor-patient relationship, thus there was no duty, and she could not be held liable for this undiagnosed cancer. So this is kind of an example where we're really focusing in on the duty here, and you can see why that's important. If you don't have a duty to another person, then you can't be held liable for negligence. But if you do have a duty and you breach that, then we're one step closer to forming a negligence claim. Well, we just looked at the duty of care. The second element of negligence is the breach of duty. The plaintiff has to establish that the defendant's conduct fell below the appropriate standard of care in order to make a negligence claim. So in a situation like when we're talking about doctor-patient, the patient who's suing his doctor for messing something up has to prove that a reasonably careful doctor with the same specialty or whatever would have ordered another test, would have understood what the x-ray was trying to say, would not have cut off the wrong leg, whatever the case may be. If we're talking about, for instance, a car accident, we would have to show that the defendant failed to look both ways before going out into that intersection and pulling forward from the stop sign. And a reasonably careful person would have looked both ways, and so the defendant fell below that standard of care. And so then if that happens, then we have a breach. Again, if you text while driving, you breached your duty to the people around you that you have a duty to look out for, because a reasonably careful person would not be texting and driving. So you shouldn't be doing that. You're breached your duty of care. And so that we have to prove that breach. Again, if we're talking about something like professional malpractice, we look at what a member of that profession would have done. There's things, there's medical malpractice. There's also legal malpractice. If an attorney messes up and doesn't file a lawsuit within the statute of limitations, which we'll look at a little bit later, and a client's case is ruined because of that, that's a breach of duty. A reasonably careful lawyer wouldn't have done that. And again, it just depends on, we look to that duty that's established and then look and see what the standard of care is, and then see if the defendant's conduct fell below that standard of care. And if it did, we have what is called a breach of duty. Let's look now at the next element of negligence, and that's having damages. The law simply is not going to waste its time hearing a negligence case unless there's an actual harm suffered. So even if somebody did something horribly stupid, they breached their duty that they had, but no one gets hurt, no property gets damaged, nothing like that, then the court's not going to waste its time hearing the case. So in order to have negligence, we actually have to have some kind of harm that was suffered. Let's look at a case where there wasn't any harm, just kind of illustrate the point here. Example number 20, Marcia is driving westbound on Highway 60. Marcia decides to text her BFF while she's driving, takes her eyes off the road. At the same time, Linda is driving eastbound. Marcia's car crosses over the center line and heads straight for Linda's car. Linda lays on the horn. Marcia looks up, and at the last minute, she swerves back into her own lane, avoiding a collision. The two cars continue on down the highway. So these cars never collided. There was no property damage. No one went to the hospital. Nobody got hurt. Really, there was no harm. There was no damages. So we have duty because Marcia, she's a driver on the highway. She has a duty to be reasonably careful, be looking around, trying to not cause an accident. She has a duty to those around her to be a careful driver. We have a breach of that duty. She doesn't, in fact, keep her eyes on the road. She's texting her BFF. She's being careless. She kind of veers into the other lane. So we have a duty. We have a breach of duty. So, we're chugging along here trying to put together a negligence case, but then we have no damages because nobody gets hurt. No property gets damaged. If for instance, Linda tried to bring this suit and won, what would she get awarded by the court? She didn't suffer any harm. And so, of course, I'm going to waste its time on a case like this. So we have to have damages in order to have a negligence claim. The duty and the breach of duty are vitally important, but there has to be some kind of harm suffered, or we're simply just not going to waste our time messing with it. Well, the next element is called cause in fact. And sometimes you'll just see this lumped in with the next approximate cause, is just causation. And I prefer to break them apart and kind of look at them separately because they are really kind of different concepts. For a defendant to be liable in a case, his actions need to have actually caused the damage that the plaintiff suffers. And we'll phrase this as but-for causation in most negligence cases. There are other things out there, and they're complicated, and we don't really care. But for 99% of negligence cases, we'll use the but-for test. But for the defendant doing blank, the plaintiff would not have been injured. And so we will look at the factual situation before us, try to determine that. If the defendant had not breached the duty in the way that he did, would the plaintiff have suffered harm? If the answer is that the plaintiff would not have suffered harm but for the defendant's activity, then we have causation. We have cause in fact. And so that is a requirement here. It may be easier to understand the importance of this element when it's absent. Let's look at an example. Example 21. Gladys goes in for surgery to remove a diseased kidney. Her surgeon, Dr. Quack, removes the wrong kidney. While Gladys is still in the hospital, she suffers a sudden brain aneurysm and dies. Medical experts agree that the aneurysm could have burst at any time and nothing in particular caused it to rupture when it did. Okay. So if Gladys's survivors sue for wrongful death, using a negligence theory here against Dr. Quack, they would have been able to establish, one, that Dr. Quack owed a duty to Gladys, and that he was supposed to be being a reasonably careful doctor here. Okay. And we also see that he breached that duty. He was not a careful doctor. He removed the wrong organ. Okay. But did that cause Gladys's harm here? Certainly there was harm suffered. She died. So we have damages, arguably. But she died not because of him removing the wrong kidney. She died because of something completely unrelated. Some blood vessel in her head exploded. Okay. Could have happened at any time when she was walking down the street or shopping in Walmart. It could have happened. Had nothing to do with anything Dr. Quack did. So, but for his negligence or his, breach of duty here, would this harm have occurred? The answer is no. Gladys would not have died because it had nothing to do with what Dr. Quack was up to. So You see the importance of establishing that the defendant's conduct was the actual cause, but for the defendant doing this wrong activity, this harm wouldn't have occurred. So that's an important element in negligence. When we looked at actual cause, or the but-for cause, there's also a separate element called proximate cause or legal cause that we have to have for negligence. Sometimes, even a defendant's conduct was a but-for cause of the plaintiff's injury, the law may still let the defendant off the hook anyway. And you think, well, why that? Well, sometimes the causation may be so far removed from the actual harm that we would say the defendant could never have foreseen that that kind of harm would occur. So it's unfair to hold them liable. Well, that's kind of fuzzy. What's that mean? Well, let's look at an example to kind of illustrate this. Example 22. Marcia, who's a bad driver apparently, we're kind of changing the facts here. She's driving westbound on Highway 60. Okay, Marcia decides to text her BFF while she's driving, takes her eyes off the road. Familiar story to this point. Okay, at the same time, Linda is driving eastbound. Marcia's car crosses over the center line and heads straight for Linda's car. Linda lays on the horn. Marcia looks up and swerves back into her own lane, avoiding a collision. Marcia keeps driving. Okay, we're changing the facts here. Marcia keeps driving, but Linda pulls over for a few seconds to catch her breath after the close call. So she kind of gathers herself, takes a few deep breaths, and Linda starts driving again. A half mile down the road, a meteor falls from the sky, hits Linda's car, and kills her. Okay, let's think about this for a second. In this case, we have duty. As a driver on the highway, you have a duty to be careful, trying to prevent harm to those around you. We have a breach. Marcia was texting her BFF. Took her eyes off the road. We already established that. We have damages because somebody died. That's damages right there. We also have a cause in fact because you say, well, the meteor is what caused the harm. Well, it is, but for this close call, Linda would never have pulled off the side of the road and taken a deep breath. So she would have been long down the road. She'd have been a couple miles past where that meteor hit before that actually fell from the sky. But for the fact that we had this close call because of Marcia's careless driving. So even though the meteor is what did Linda in, Marcia's conduct of breaching her duty here, that was a but-for cause of the harm that was occurring here. But we have to ask the question, was this harm actually foreseeable? When Marcia, had this close call, did she drive away thinking, oh my goodness, I breached my duty, and because of that, I hope no one gets killed by a meteor? Is that really foreseeable? Is that reasonable to expect that she would have ever anticipated that her reckless driving would have made meteors fall on people and kill them? No. And so, in legal terms, the meteor falling from the sky is an unexpected event that lawyers would say breaks the causal nexus between the breach of duty and the injury to Linda. In other words, the meteor is what a lawyer would call a superseding intervening cause. Something that comes in is so unexpected, it really relieves the person committing the tort here, or would otherwise have committed the tort, from responsibility. Because yes, their action was bad, it was a breach of duty, it was a but-for cause, but that's really not enough here, because there was some other thing that just came out of the blue that really is with the immediate cause of the harm that no one could have ever foreseen happening. And so we kind of let Marcia off the hook here because of that. Let's look at example 23. And kind of another example, but it's a lot closer. It says, Bill runs a red light and hits Ted's car. Okay, Ted has a broken leg, but is otherwise uninjured. An ambulance comes to take Ted to the hospital. On the way, the ambulance is hit by a train and everyone in it is killed, including Ted. Okay, instead of a meteor here, we basically traded the meteor in for a train. So do we let Bill off the hook after he ran the red light, breaching his duty and causing some harm here? Actually, probably not, because even though that train, is not under Bill's control here, he wasn't the immediate cause of the death. that occurred. He put a chain of incidents into motion here that he could have foreseen, something like this would happen. You think if you run a red light, someone might get, hit and killed. You think that they might have to go in an ambulance to the hospital. We know that ambulances also have accidents. I mean, this is foreseeable in a way that the meteor is just literally out of the blue in this case. So this is a much closer case. But the principle here is that, just because we're the but-for cause of something doesn't mean that we're legally responsible. Sometimes the law just says, okay, well, it's too far removed. Think about, also, would we put Hitler's mom on trial for the Holocaust, but for the fact that she gave birth to Hitler and raised him the way she did, he wouldn't have gone and killed, millions of people in the Holocaust. Do we hold her responsible for that? But for her giving birth to Hitler, the Holocaust wouldn't have happened, but is she, proximately responsible for that? The answer is no. So you see that the law just kind of, uses some logic and reason here to prevent us from being sued for things we could never have ever anticipated that our actions would cause. And so proximate cause is another very important part of negligence, and we have to have all 5 of those elements or we don't have negligence at all. All right, well, we've seen the basic elements of negligence. Let's look at some specific special types of negligence. This, fits under the umbrella of negligence. It's just, particular applications of that tort theory. The first one we'll look at is negligent infliction of emotional distress. Remember that we had an intentional tort, intentional infliction of emotional distress. This is the same idea, only the harm happens because of negligence, not because of some intentional bad act. The plaintiffs here, they may be able to recover for emotional distress that was inflicted because of negligence, even if they don't suffer a physical injury, just like we saw with intentional infliction of emotional distress. Here's an example 24. Ralph died in a fiery car crash and his body was heavily disfigured. Bad stuff. His family had a closed casket service at Smith's funeral home. As the casket was being carried out of the funeral home to the hearse for the trip to the cemetery, one of the pallbearers stumbled and the coffin shifted. A Smith's funeral home employee had negligently failed to secure the latches on the casket prior to the service, so the lid came open. Ralph's disfigured body fell out of the casket and landed on the pavement right there in front of Ralph's horrified family. No physical harm happened here. Ralph is dead. We can't hurt him any more than has already been done. His family didn't suffer any physical harm. He didn't land on top of them, but seeing that, you can imagine the trauma that they would go through, seeing their loved one's mangled body, bouncing around on the concrete here. This is terrible. So in a situation like that, even though there was no physical harm, there may have been emotional harm. We'll let them recover for that. So again, very similar to intentional infliction of emotional distress, but there's really no intent. It's just somebody screwed up and didn't do what they were supposed to do. Continuing our look at special types of negligence and doctrines dealing with negligence, let's look at negligence per se. This is a special situation where a statute or regulation of some kind will define for us what the standard of care demands in a particular situation. Let's take, for example, a situation where you have a truck driver. And a commercial truck driver is bound by certain regulations, and let's say that those regulations require him to inspect the brakes every time before he gets behind the wheel and takes off in his truck. And our truck driver does not do that. And so he comes up to an intersection, his brakes fail, and he causes an accident. Well, the plaintiff in that case, who was hit by this truck, he can show that the truck driver failed to follow this statute or regulation and did not inspect his brakes. And so in that situation, that statute or regulation is defining what the standard of care is. Normally, we might leave that to the jury to figure out, what would a reasonable person do in that situation? Well, here we don't have to have that uncertainty because the law tells us, thou shalt inspect thy brakes before every trip in thy truck. And so in a situation like that, if you can show that the truck driver didn't do that, then you have established that he was negligent. And so it makes it easier for a plaintiff because we have the standard of care defined for us by statute. So that can be very helpful to a plaintiff in certain situations. We have another doctrine called res ipsa loquitur. It's pronounced res ipsa loquitur, or just res ipsa for short, another Latin phrase. It means the thing speaks for itself. And it's kind of an odd doctrine because it shifts the burden of proof from the plaintiff to the defendant in certain negligence cases. And of course, normally the burden is on the plaintiff to prove his case. He's the one who must bring forth the evidence to establish all the elements of a tort in order to prevail at trial. But in this situation, we'll kind of give the plaintiff a break because sometimes there is something that obviously went wrong. The plaintiff has suffered some kind of harm that wouldn't have happened if negligence hadn't occurred. But for whatever reason, it's almost impossible for the plaintiff to really pin down exactly who did what. And so let's look at an example of this. This is example 25 for res ipsa loquitur. It says, once upon a time, soda pop came in glass bottles. Fizzy pop, of course, is under pressure, and if the glass bottle ever developed a crack, the internal pressure would cause the glass bottle to explode. And that was a big problem, because from time to time a pop bottle would explode in a supermarket, sending shards of glass flying through the air and frequently injuring people in the store. And some of those were really nasty incidents. Rough treatment at any time during its trip from the bottler to the store could cause a bottle to develop a crack that would lead to an explosion. Thus, an injured customer in a grocery store could potentially point the finger at the grocery store, any trucking company that hauled the bottle, or the bottler itself. Unfortunately, the poor customer would have no way of proving which one of those potential defendants actually mistreated the bottle. And so let's stop there for a second and imagine if you're that plaintiff and it's up to you to prove who was at fault. You sue, let's say, the grocery store, the trucking company, and the bottling company. Well, what are those defendants going to do? They're going to point the finger at each other. The grocery store is going to say, well, it wasn't my fault. It was cracked when it got here. And the trucking company is going to say, well, it's not our fault. It was cracked when we picked it up. And the bottler is going to say, no, it wasn't. It left our factory just fine. And one of these other guys must have dropped it somewhere along the way. Well, and the plaintiff's not going to have any way of satisfying the burden of proof on that. And so what the law would do is let the customer sue everyone who touched the bottle under the doctrine of res ipsa loquitur, and then the burden would shift and be up to the various defendants to prove that they were not negligent or that one of the other defendants was. And so that burden of proof was shifted over. So kind of an odd doctrine. It does come up from time to time. It's not terribly common, but it's certainly worth mentioning. It comes up a fair amount of time in medical malpractice, and honestly, plaintiffs' attorneys really don't like the doctrine that much because juries really like to hear a theory of the case. They want to know what happened. They want you to tell them, well, what do you think happened? And if you're just saying, well, I don't know what happened, but something went wrong, then they're not really going to, like that too much. So it's not that popular, but it does happen. And here's another example, this time from medical malpractice. A patient goes in for surgery on his kidney. He wakes up after surgery and has no feeling in his left arm. The surgeon wasn't even supposed to be working on the arm. The patient knows that something had to have gone wrong, but has no way of knowing who screwed this up since he was, anesthetized. He was asleep. Was the surgeon? Was it the anesthesiologist? One of the nurses? We don't know. But under res ipsa, the patient could sue them all and force them to prove they were not negligent. So that's another way that this doctrine comes up from time to time. Again, not terribly common, but common enough that I thought you needed to know about it. Well, res ipsa comes up in situations where two things are true. One is the injury would not ordinarily have happened unless someone was negligent. So it's not the kind of thing that just happens through an act of God or through, just pure chance. It's pretty clear somebody screwed something up. And second of all, the plaintiff really had no control over what was going on. It was totally under the control of the defendants. So, the customer in the grocery store is walking past the glass bottle and it just explodes. He had nothing to do with it. Or the patient, is knocked out on the table and the defendants are the ones conducting the surgery, has no idea what's going on. Situations like that is where they let the plaintiff get away with this burden shifting of res ipsa. It's helpful to remember the origin of the name comes from the situation the plaintiff finds himself in. He's hurt. It's obvious that someone was screwed up and caused it, so his situation speaks for itself, which is what res ipsa loquitur actually means. So again, not terribly common, but common enough that it's worth remembering something about. Continuing with our special types of negligence, let's talk about Good Samaritan laws for a second. Good Samaritan law is something that will relieve people of liability in certain situations where otherwise they could be sued for negligence. The reason for this is because we want to encourage people to try to help folks who are in trouble. Let's look at an example. Number 27 here. John is driving to work when he has an accident. His car strikes a tree. Wilma sees this happen and stops to help. She pulls John from his mangled car and waits for an ambulance. So Wilma's being very heroic here. She didn't have any obligation, but she stopped, tried to help, tried to rescue this guy from his car, and summon an ambulance here. But unknown to Wilma, John's neck was fractured. When she moved him, his spinal cord was severed. So she didn't know this, but if she had just waited for the ambulance, they might have been able to get him out and not cause any damage to his neck. But since his spinal cord is severed, it paralyzes him from the neck down. So poor Wilma, she's trying to help. She's doing, things that a stand-up citizen would do, trying to rescue this stranger. But since she caused this damage, ordinarily John can sue her for negligence, which is maybe kind of a dirty thing to do ethically, that, she was just trying to help. She was trying to save him. But instead she ended up causing accidentally quite a bit of harm, so he spends the rest of his life in a wheelchair. Well, a Good Samaritan law will try to protect the Wilmas of the world in this kind of situation because, we want to encourage people to be Wilmas. We want people to try to stop and help and provide assistance to those who are in need. We don't want them to be thinking, oh no, I could pull this pregnant lady from the burning car, but I don't want to get sued if I screw something up, So we don't want people to stop and think about that. We want them to just go help. And so to encourage that, some states have protected Wilma in this situation through what's called a Good Samaritan law. We also have something called Dram Shop Acts. And a Dram Shop Act basically makes bars legally liable when they serve alcohol to a customer who becomes intoxicated and then leaves and kills someone on their way home because they are driving drunk or injured, not necessarily killed. But sometimes, a bar will keep serving someone when they should have stopped serving them and called a cab for him. And so in situations like that, legislatures have allowed a liability to attach to owners of these establishments when they fail to stop someone from becoming intoxicated and leaving and then going out and causing havoc when they're on their way home. The victim then in that situation could sue the drunken driver, obviously, who caused the accident, but they can also sue the bar who served the alcohol. In some states, you can also sue an ordinary individual, not just, a drinking establishment, a bar or a restaurant or whatever, but say, there's a private party, a wedding or something, one of the guests gets drunk and goes out and hurts somebody. This is referred to as social host liability. And some states have this and some states do not. We also have something called guest statutes. These used to be a bigger deal than they are today. But they're a lot less relevant than they used to be. We don't see them that much in the case law anymore. But basically, this would keep the driver of a car from being sued by a passenger who is riding along in the car free of charge. The idea is that basically state legislatures wanted to protect somebody who was so nice that they were giving someone a ride for free from being sued by the person that they were giving a ride to because they were a bad driver. So this is what a guest statute would do. It doesn't provide immunity from gross negligence. So if the driver of the car was, driving while intoxicated or going 100 in a 45 or running every red light or something like that on, drag racing, something like that, we wouldn't provide immunity in those situations. But in a normal situation, the driver of the car would be immune from being sued by the passenger who's riding along for free. Interestingly enough, if the passenger had paid for the ride, then the driver owed them a duty of care. And so, if Bob gives a ride to Tom and Tom is riding for free, then he couldn't sue Bob for driving carelessly. But if he was paying $50 to get a ride to Kansas City or something, then he could sue if the car went off in the ditch. So Does that make any sense? Probably not a lot. I don't think so. But it did to state legislatures at one time. All right, continuing with special types of negligence or situations, we have rescuers. And there's something called the fireman's rule. And this applies not only to firemen, but also policemen and other rescue workers. And basically, it says that those rescue workers who are working for the government, pretty much, going around and trying to keep peace and order and rescue people and cats and trees and that kind of stuff, they cannot sue a person whose negligence caused the emergency they're trying to help with. So let's say that Susie's trying to have a barbecue and she somehow catches her house on fire because she's on a wooden deck with her barbecue grill or something, and a firefighter shows up and tries to rescue Susie's family from the house and falls in a hole and breaks his leg or something and tries to sue Susie. We won't let that happen because of the fireman's rule. Because it's his duty, and he signed on for this kind of work, and we're not going to allow him to sue the people he's trying to rescue. So that's what the fireman's rule says. And part of that is, the public policy aspect of it. If somebody accidentally negligently sets their house on fire, we want them to call 911. We don't want them to stop and think, oh no, I can call the fire department, but if I do, they might break a leg when they get here, and then I'll get sued. And then think about it, for a couple of minutes while the fire is spreading and catches their neighbor's house on fire and whatever else. We don't want them to hesitate. We want them to not mess around, but call 911 and get the emergency people there. So that's the fireman's rule. It only applies to government agency workers. So, if Susie's neighbor jumps in and tries to rescue her from her burning house and gets hurt, he can sue Susie, potentially. And the fireman's rule doesn't apply in a situation like that. All right, continuing on, let's look at landowner liability. If you own land, or a home, whatever, real property, and then you owe a duty of care to the people who enter onto that property. So you have this duty to protect them from dangerous situations that might exist. Traditionally, the law determined what a landowner's duty actually was based upon the status of the people who were on that property who were trying to sue you. We had three major categories of people. An invitee was someone who came onto your land at your express invitation. If you invite me over for dinner and I show up, and then you owe me a particular duty of care, a higher duty of care than the others, actually, that we're going to look at. So that's one type of person, and it's basically a mutual benefit situation. A licensee, on the other hand, is for their own benefit, but they're there with permission. Like an invitee, you invite me for dinner. I'm going there to get the dinner, which is a benefit to me. You're getting my company, which is a much, an important benefit for you. And so, we both have something going on there. A licensee, it might be something like, a salesman that shows up or something. They're there more or less with permission. You haven't told them to leave, but, they're really there for their own benefit and really not your benefit. So they're there to conduct business or something else, not social. It's not a social call. A trespasser, on the other hand, is there with no permission whatsoever. So they're just, jump the fence or whatever, or, you didn't ask them to come there. It's no benefit to you at all. They're just there without permission. Well, under the common law, when we had this classification system, and we still have it, it's just a little less rigid than it used to be, I guess. You would owe a certain duty to invitees and licensees of ordinary care, certainly. You had to make sure that, look out. If there's any dangerous situations, you would need to correct that. Before you invite me over for dinner, you'd have to make sure that you've covered over the hole in your front walk, that I'm not going to fall in it and break my neck or whatever. So you have to kind of look around and make sure that there's no dangerous conditions there. So, basically a duty of ordinary care. Trespasser, however, you do not owe a duty of ordinary care to. In other words, you just basically have to not injure them on purpose. So you cannot dig a pit and put a hungry tiger at the bottom of it, hoping to catch trespassers. Can't set out booby traps for your trespassers, but you don't have to fill in all the holes thinking, a trespasser might come through here. I really don't want them to hurt themselves. Well, you don't have to go out of your way to make it safe, in case a trespasser might happen along. But you do have to not do anything overtly hazardous or something like that, or try to injure them on purpose. There is a situation sometimes where you might have a situation on your property that will actually attract children. That's called an attractive nuisance. I won't go into that in great detail, but if it's a particular hazardous situation that that kids would love to play on my old broken down whatever, and they might fall off and get killed, you might have a duty to do something about that, even if the kids are technically trespassers. So again, this doctrine's broken down a little bit, but you owe a duty of ordinary care to people who come on your land with some kind of permission. A trespasser, you owe less of a duty there. So anyway, that's the different classifications of folks who can end up on your property. Okay, common carriers and innkeepers. A common carrier is a person or a company that is in the business of transporting people in exchange for money. So a taxi cab company, Greyhound bus service, United Airlines, anything like that is considered a common carrier. An innkeeper is someone who owns or runs a hotel or motel or anywhere else that people pay to spend the night. So, Super 8 or Motel 6 or the Four Seasons or whatever, something like that. Most states hold innkeepers and common carriers to a higher standard than ordinary care. So basically, you're entrusting your safety to these people when you're on their bus or in their motel or whatever. And so there's a higher standard that they have to follow in looking out for you while you're there. So that's why this is a little bit special for these folks. Okay, another special type of negligence situation is that of wrongful death. It's really not a different kind of cause of action. It's just based upon who's bringing it. Because at the common law, think jolly old England, like 1550 or something like that. When a person died, their right to sue died with them. And so if you're driving your ox cart negligently through the city of Cambridge or something in England, and you run over somebody, you kind of hope that they pass away, because if they survive and recover, then they can sue you. But if they die, then their lawsuit dies with them. And because if they're not able to show up in court and accuse you of committing a tort, then that's that. And when they die, their cause of action dies too. That's manifestly unfair, because we don't want to let people off the hook just because they were so bad at committing torts that they killed people. So in every state and country that follows, the Anglo-Saxon law heritage or whatever, wrongful death statutes have been passed that now allow the surviving kin to sue whoever negligently caused the victim's death. Each state specifies who those relatives are, who can bring a claim, and what types of damages they can recover for the death of a loved one. So this is kind of unique because basically they take on someone else's right to sue. And so when that person dies because of negligence or whatever, then their surviving relatives have that right to bring the claim that the dead person would have been able to bring if they had survived. So that's what a wrongful death action is. So as a tort committer, you cannot get off the hook just because your victim passes away. Let's talk now about something kind of special, which is called strict liability. And strict liability is different because really you don't have to have done anything too terribly wrong to get in trouble in this situation. Some activities are just so dangerous that the law calls them ultra hazardous. Think about if you're handling dynamite, or blowing up old buildings, and demolishing them, something like that. That's just so stinking dangerous that it's just kind of a normal thing if somebody gets hurt. So in those situations, even if the people are doing the activity with ordinary care, someone might still get hurt. And in those situations, even if they're exercising ordinary care, we still, want them to compensate somebody who's getting hurt in this situation. So let's look at an example. Carterville Construction Company or CCC, is demolishing a high-rise building in downtown Kansas City with explosives. This is an ultra-hazardous activity. Even if CCC does everything correctly, someone might still get hurt. They set the charges off. A brick flies up in the air and comes down 3 blocks away on top of Doug's head. CCC is liable to Doug for his injuries, even if they were not ordinarily negligent. So even if, in other words, even if they didn't really breach the duty of ordinary care, because what they were doing was ultra-hazardous, they're still going to be liable for the harm that arises from that. So they can't escape liability for something like this, even if they were being ordinarily careful. So basically, we don't really care so much if they're at fault or in the wrong, but they were responsible for doing this ultra-hazardous thing. They knew someone was likely to get hurt, and they did get hurt, and so they're going to pay for that. So they get to pay the victim whether they did anything wrong or not. And so that's liability without fault, which is kind of unusual, I guess, in a way, because normally we expect someone to be right and someone to be wrong in a lawsuit. Here, they may not have actually done anything wrong, but we're still going to hold them liable because, it was their activity that they were doing. And so even if they did everything right, someone still got hurt, so they're going to pay for it. Okay, let's shift gears a little bit and talk about defenses against negligence. So you get sued and someone's accusing you of negligence. Okay, there are 2 types of defenses that may be available to you. One is an ordinary defense. And what you're saying with an ordinary defense is that one of the elements of the tort is missing. So we know that there are several different elements of negligence, and we're just saying that, one of those elements is not present. For example, you might be saying, yes, I had a duty. I was supposed to be exercising ordinary care, for example. Yes, I breached that duty, but my actions didn't actually cause the damages the plaintiff is complaining about. And we looked at examples where causation was missing. So if you're in court arguing that, well, yes, I messed up, I had a duty, I breached the duty, but I wasn't the cause of it, or you might be arguing I didn't have a duty in the first place, or there was no breach, or whatever it is. In a situation like that, that's an ordinary defense. Remember example 22 where the meteor killed Linda after the close call on the highway? Well, in that case, we said there was a superseding intervening cause. In other words, causation was not present. So that's exactly what we were looking at, in the bullet point just before this. So there was a duty, there was a breach of duty, but the actions, maybe it was a but-for cause, but it wasn't the proximate cause of the injury. So one of those elements is missing. That's an ordinary defense. You're just saying, well, you haven't proven your case, plaintiff, because you haven't shown that all the elements are there. Well, the other type of defense is an affirmative defense. In this situation, when you assert an affirmative defense, what you're really saying is, plaintiff, you've proven every single element of the tort. There are 5 elements of negligence. You've proven every single one of them. But I should still win because of fill in the blank. And that blank is the affirmative defense. And so even if everything the plaintiff says is right, there is all the elements of the tort have been proven by the plaintiff, the defendant should still win because of something else. And if that something else is an affirmative defense. Let's look at different affirmative defenses. One of them is called assumption of the risk. Let's look at an example of this. In example 28, Jim and Aaron like to play with guns. They're out in the backwoods target shooting one day. Aaron says to Jim, "Hey, I bet you can't shoot that tin can off of my head." So Jim takes the bet. Aaron stands 50 paces away with the target on top of his head. Jim shoots, but of course misses and hits Aaron in the shoulder. Aaron wants to sue Jim for negligence. Well, what do we say to Aaron in that situation? First of all, you're an idiot. Second of all, you should have known what you were getting yourself into. And that's what assumption of the risk really is. It's telling the plaintiff that, look, you're partially at fault for your own situation here because you're an active participant in the risky activity that led to your injuries. You knew what was going on. So, it's like somebody shows up and asks somebody to let them into their alligator farm so they can go pet the alligators, and they know full well that alligators like to eat people, but they want to go out in the pasture and pet the alligators, okay? If you're knowingly exposing yourself to a crazy risk, and then you get hurt, which is, shouldn't be a surprise to you, and then you want to complain about it. Well, the law kind of takes a dim view of that. If you knowingly put yourself in harm's way, we don't want you to blame someone else for your misfortune. So that's what assumption of the risk is. Our second affirmative defense is called contributory negligence. In negligence cases, this doctrine has been replaced by something we'll look at in just a second, so it's not that common anymore. But in older cases, this was a real problem for a plaintiff. Under the old common law, a plaintiff could not recover damages for negligence if the plaintiff's own negligence played a role or contributed to causing his own injury. Well, you may know this if you've ever had any kind of car accident. Insurance companies like to say that somebody was 80% at fault and someone else was at 20% at fault, for example. Well, even if the other person was 80% at fault under this doctrine, if you contributed to cause your own injury, were only 20% at fault, you didn't get to recover anything. And that was kind of unfair. So let's look at this example. Ben is driving down the road doing 80 and a 55. So that's pretty reckless. Mark, who isn't watching what he's doing, pulls his car out in front of Ben and there's a collision. So both people are probably doing something they shouldn't have done. But Ben sues Mark for negligence because he failed to yield the right of way and pulled out in front of him. Mark counters that Ben was speeding. If he'd been doing the speed limit, he would have had time to stop before hitting Mark and wouldn't have been injured. So we have two people, neither of which has completely clean hands in this situation. Both of them are doing something a little bit negligent. Under the common law, if Mark could prove that Ben was also negligent, Ben would recover nothing from Mark. So even though Mark was partly or even 99% to blame, if Ben was even 1% at fault, he would get nothing. So that is kind of unfair because you might have a situation, like I said, where somebody is only 10% at fault. The other guy is, 90% at fault. But the 10% guy can't recover anything from the 90% guy because he was partly to blame, is how the law looked at it. And they just wanted you to be an innocent little angel in order to recover anything. And so that's the way the law used to be, and almost everywhere that has gone away. What we have now is called comparative negligence. Most states have replaced that contributory negligence regime with some variation on comparative negligence, or what we call comparative fault. In this situation, the jury will decide how much at fault the plaintiff was and how much the defendant was. So let's take an example, kind of changing the facts, is example 29. It says only this time in a state that uses comparative fault. Okay, the case goes to the jury. The jury determines that Ben was negligent because he was speeding, but Mark was negligent for not watching where he was going. So we knew they were both at fault. They decide that Ben was 20% at fault in causing the accident, while Mark was 80% at fault. They find that Ben suffered $100,000 in damages. However, since he was 20% at fault, they deduct 20% of his damage award, or they take away $20,000 that he would ordinarily have gotten if he had no fault at all. So Ben wins the case, goes home with $80,000. And that kind of makes sense because the person who was most at fault is the one who pays. The person who was somewhat negligent, but not, the main cause of the accident, they suffer a little bit. You take away some of their damages, but, we don't completely shut them out entirely. So that seems to be a more fair way of looking at these sorts of cases. With comparative negligence, each state handles it a little bit differently. Missouri is called a pure comparative fault state. Even if you were 99% at fault and causing your own injuries, you can still sue the person who was 1% at fault, and you'll win, maybe, but even if you do, your damage award will be reduced by 99%. So in other words, you can be the driver who's most at fault. You can still win your case. You might recover something, but it'll be reduced by the total percentage of your fault. So in reality, you probably wouldn't want to do that because the other guy who was less at fault than you will sue you back. But anyway, theoretically, this is how it would work. Other states, such as Arkansas, use modified comparative fault. In Arkansas, you can't recover anything unless you were less than 50% at fault. So if you were 51% at fault, the other defendant was only 49% at fault, you'll recover nothing. However, if the defendant was 51% at fault, then you can win and your damages will be reduced by 49%. So you have to be less at fault than the other guy to win. But if you do win, then your recovery will be reduced by the amount that you were at fault, and you'll recover something at least. So different states handle this in different ways. Another very important affirmative defense is the statute of limitations. And you've probably heard of this idea. Basically, the law doesn't want someone bringing a lawsuit too long after an incident occurred, and there's some good practical reasons for that. Now, one is, witnesses are hard to find, evidence has been lost, and that kind of thing. And also, we want people to, have some kind of peace of mind, not lay awake at night wondering if they'll get sued for something that happened 30 or 40 years ago. So, with every different cause of action, the law prescribes basically a time limit that if you're going to sue based on that cause of action, you have to do it within a certain amount of time. And that's kind of an arbitrary time limit, but it's very, very important. So even if a plaintiff has a perfectly good claim, can prove all the elements of the tort, if you wait too long after the statute of limitations time has run, you'll still be thrown out of court. So even if you prove all 5 elements of negligence, if you wait too long to file your claim, you'll lose. How long you have to file depends on what state you're in, also what case you have. In Missouri, for instance, you have 5 years to file most tort claims, including negligence. But if it's a wrongful death claim, you only have 3 years. If it's medical malpractice, you only have 2. And so it's very important to understand what kind of case you have and what your state law says, because that's how you know how long you have to file. So the important thing is you don't want to sleep on your rights, because if you wait too long, doesn't matter how good your case is, you'll still lose. If you wait till, the one day after the statute of limitations has run, you no longer have a claim. It just disappears. So very important to understand the statute of limitations and not let that run out if you have a claim that you might be able to make. Let's talk now about products liability. This is dealing with situations where somebody manufactures a product, a consumer buys the product, there's some kind of defect, somebody gets injured, something like that. Then we have what's called a products liability case. Now, the law treats these cases a little bit differently than ordinary tort cases. We can have some examples of where something like this might happen. You may have heard of things like this on the news. Let's say a car maker messes up, a defective part causes the car to slip into reverse and run over somebody, and that's a products liability case. Maybe a coffee pot has some kind of electrical problem and starts burning houses down when you leave it going when you're not home. You might have a baby crib with a defect that causes infants to fall out and get hurt. All of those would be examples of products liability cases. One thing is important to understand about products liability is we're not dealing with one specific tort theory. There are actually several different theories that are available that a plaintiff might use to sue a manufacturer of a defective product if they are injured. The first one's familiar, that's negligence. You can just file a normal garden variety negligence type claim under products liability if you're injured by a defective product. There are several different ways that a manufacturer might be found negligent. One is by negligent product design. In other words, the manufacturer goofed when they designed the product. They ended up making it more dangerous than it had to be, and that led to injuries. For example, the White and Becker Company manufactures power tools. They make a power saw but neglect to put a safety switch on it. If the operator lets go of the saw, it may keep running, and so a customer who bought the saw accidentally cuts off a toe because the saw didn't switch off when he dropped it. So if they designed that saw a little bit better, put in an extra safety switch, then it would never have done that. And so they made it more dangerous than it really had to be. And so that would be an example, potentially, of a negligent product design. Another way that negligence might be proven in a products liability case is through negligent inspection or testing. In other words, the manufacturer designed a good product. It wasn't designed poorly, but they should have made sure that each one coming off the line was safe to use before it was shipped, and they didn't, and somebody got hurt. So imagine, for instance, that you have a company that's making those propane bottles that you use with a gas grill, and they're supposed to inspect each and every one, but they miss one, and it had a bad weld on there, and somebody's trying to barbecue, and their propane tank explodes and hurts them. So that would be a situation where they might have been negligent in their inspection regime, that they didn't, look at each one coming off the line and make sure that it wasn't going to hurt somebody. So there's an example of that. Here's another example, number 33, Dragonfly Inc. makes airplanes. They're legally required to inspect every airplane that they make to ensure that it's safe to fly. However, they produce one airplane where the inspector failed to see that a cable was disconnected. A customer buys the plane, but the disconnected cable causes it to crash, killing the pilot. So Again, we want to make sure, even if you design a product correctly, we want to make sure that you catch any defects coming off your factory line. Another negligent theory that we might use is negligent failure to warn. Sometimes products are dangerous. It's not that they were poorly designed or manufactured, but it's just not possible to remove that danger. But if a reasonably careful consumer wouldn't have recognized that danger on his own without some help, then the company has a duty to put warnings on the product explaining the danger and how to avoid it. For example, Warm and Fuzzy Inc. makes electric blankets. They know that turning on the blankets when they're folded up can cause a fire. But the instruction booklet with the blankets does not warn customers about this. A customer buys a blanket, finds out that it warms faster if she keeps it folded up after she first turns it on. She does this one day, but the blanket overheats, starts a fire, and burns down her house. So an ordinarily careful, reasonable consumer might not have realized that that would be a problem. This thing that keeps my feet toasty at night, might burn down my house. Never crossed their mind. But the company knew that, and if they just put a little warning label on there, it might have stopped this from happening. So negligent failure to warn is another theory that you might use. Well, negligence isn't your only option in products liability. There's also a strict liability theory that you can use. Because negligence is so hard to prove in a product's case, most states have adopted some kind of strict liability regime. It's the same type of no-fault liability that we looked at back in example 31 earlier in this presentation. Basically, if a plaintiff gets hurt by an unreasonably dangerous product, then they can successfully sue. And you don't have to prove, that somebody did something wrong. You don't have to prove all the elements of negligence, just that the product was unreasonably dangerous. I got hurt. And that's really all you have to do. Interestingly, this doctrine reaches more than just the original manufacturer. Now let's take a look at an example here. Example 35, High-Tech Inc. manufactures various components for computers. They make cooling fans for PCs and sell them to Computech. Computech then manufactures computers and installs the fans from High-Tech in their machines. They then sell a batch of computers to Global Distributors, a wholesale dealer in computers. Global Distributors then sells the computers to Computer Shack, a retail store. George buys one of the computers from Computer Shack. It turns out that the cooling fan in his machine is defective. His computer overheats, starts a fire, and burns his house down. Under the doctrine of strict products liability, George can successfully sue Computer Shack, Global Distributors, Computech, and High-Tech Inc. So basically anyone who touched the fan or the PC through the distribution chain can be liable in a situation like this. So very powerful tool if you're a plaintiff. Well, as we said, any company in that chain of distribution can be sued. State legislatures basically made a policy decision on this. If you're wondering, well, is that really fair? It wasn't the distributor's fault. They didn't know. Well, the decision was made. It was better to ship the cost of defective products to those companies than force consumers to suffer and prove which company messed up before they can recover any damages. Because we know what would happen if we didn't have this. The plaintiff would sue, and maybe all the different defendants would be pointing the finger at each other. It'd be hard to prove who was actually at fault or who should have known what when. And so we just do away with all that and basically let the defendants sort it out with each other if they have a problem with it. Companies have two ways that they can deal with all this. One is they raise the prices of their products and make us pay for it as consumers so that they can buy insurance to deal with these kinds of situations. Also, one of the companies who didn't mess up can turn around and sue the company that really did, so they can pay the plaintiff, if they suffer a judgment, but then they can turn around and sue the company that was truly at fault, that really did, was guilty of negligence or whatever, and turn around and sue them and recover whatever they actually paid the plaintiff. And so basically this policy forces the different companies in the distribution chain to point the finger at each other. Also, it's worth pointing out, usually anyone who's injured by a defective product can sue. It doesn't matter if they purchase a product brand new or used. And so if you're talking about a defective can opener and, somebody buys it, brand new from Walmart, and then they use it for a couple of years and put it in their garage sale, and person two buys this can opener and it burns their house down because of an electrical short, they can still sue. It doesn't matter if they were the original purchaser or not. Well, you might think that, goodness, this is really tough on companies that manufacture and sell stuff. And maybe it is, but they do have defenses available to them. One of their defenses is um, basically any defense that would work on a normal negligence case. If you're being sued for negligence and product liability, you can apply any of those defenses we looked at for negligence, such as superseding intervening cause, assumption of the risk, all those different things that we looked at. All those would apply to a negligence case under products liability. Some defenses, though, are unique to products case. One defense in a products case is if the danger that hurt the plaintiff was generally known. And that would be a situation like everyone ought to know that knives are sharp. And so there really is no need to put a warning on a set of steak knives that you buy saying, warning, these knives are sharp, they might catch you. Everybody ought to know that. Or warning, this gun that you're buying shoots bullets and bullets hurt people. We ought to know that already. So if the product is really can't be designed to be any safer. If you design a dull knife, it won't work as a knife. So, knives have to be sharp. So we can't really design that out of there. It's not really design flaw. It's just an inherent thing that comes with owning a knife, and everyone knows that knives are sharp. You can't really get in trouble for that, at least in theory. So that's one defense. Assumption of the risk still works in products cases if the consumer actually knew about the dangerous condition or whatever and kept going anyway. And that could be a defense. If the product is misused, that could also be a defense. For example, let's look at number 36. Woodtech Inc. manufactures chainsaws. Carlos buys a Woodtech chainsaw. Carlos's wife, Belinda, decides to use the chainsaw to give her husband a haircut. When she does so, shock and horror, Carlos is injured. Who saw that coming? Carlos tries to sue Woodtech for a dangerous and defective product. Well, in this situation, this is kind of a silly example. It's not even close, but you do have situations where people will use a product in a way the manufacturer never ever intended. And so in a situation like that, we won't hold the manufacturer liable because the consumer was just an idiot and used this product in a way that the manufacturer never intended. And for a manufacturer to be held liable, basically the type of harm that happens has to be foreseeable. Now, if it is foreseeable that the consumer might misuse the product in one way or another and might not understand that that's going to cause problems, then they might still be liable for that. So let's say that you had a drug, for example, that was only used to relieve headaches and using it in any other way was dangerous. Well, if the consumer, was used to using this drug to treat his headaches and then he had a backache and he took it for his backache, but it wasn't designed for backaches and it caused some kind of problem and there was no reason for him to understand that would have happened, then maybe the manufacturer is still liable if they didn't give some kind of warning for that. So, it just depends on the particular facts of the case. In our chainsaw case, that's just a crazy incident. And of course, we're not going to hold the manufacturer liable, but other times, it's a little more close than that. All right, well, product recall is another possibility for a special defense in a products liability case. We probably all know that products can be recalled by the manufacturer from time to time if they discover a defect and they try to get a hold of anyone and everyone who's bought or who owns this product, trying to get it fixed or make the problem right before it causes any more havoc out there. Well, let's say that you have a situation where somebody has one of these products that has been recalled and they didn't hear about the recall for whatever reason, so they keep using it and they end up getting injured by it. Okay, well, the company, when after they're sued, they can say, well, look, we issued this recall. We were very upfront about this. We tried our darndest to get in touch with anyone and everyone that had this problem. We put ads in newspapers. We put ads on TV. We sent out letters to people who had registered the product. We did everything that we possibly could to prevent this from happening. And this plaintiff was just, not minding the store and wasn't, looking at the things they would have been looking at. They might have got a recall notice in the mail and threw it away without reading it or something. If they tried to recall this product and do the right thing and the plaintiff still, didn't get the memo or whatever, we might let the defendant off the hook in that kind of situation. Also, if the product is materially altered between the time it left the factory and ended up injuring the consumer. Let's look at an example here. Number 37. Ed buys a Grass King brand riding lawnmower with a 14 horsepower engine. Not satisfied with the available power, Ed replaces the engine with a Chevy 350. that formerly resided in a Corvette and puts out about 300 horsepower. So just a little bit of an upgrade there. While mowing the yard, the lawnmower gets away from Ed and he crashes into an outbuilding, severely injuring him. He wants to sue Grass King for making a dangerous lawnmower. Well, obviously an absurd example, but you can see the principle at work here. If the consumer has done something to this thing that the manufacturer never intended, had no idea anyone would ever try doing this, and then the consumer gets hurt, we will put the blame more on the consumer in that situation than we would the manufacturer, and potentially let the manufacturer off the hook in that situation because the product that actually caused the injury was not the product they designed or manufactured or turned loose on the public. And so we'll kind of give them a break in that situation. Our old friends, contributory comparative negligence would also potentially apply. If the plaintiff who got injured with using this product was being a moron and did something they shouldn't have done, we might let the company off the hook in that situation. And so those theories apply. Also, of course, statute of limitations. We have a statute of limitations for basically any kind of cause of action, and so that includes products cases. So if the consumer gets hurt by a product and then waits too long to file suit, they're going to be up the creek because their action will be barred by the statute of limitations. All right, well, we finally made it to the end. Thank you for sticking with me. We had a lot to do in this chapter, and lots of torts out there. So thank you for sticking with it. Hope you learned a lot, and have a good week.